Hi, I'm Michael Ruger. I'm the managing partner at Greenbush Financial Group, and today we're going to be going over the distribution options that are available to non-spouse beneficiaries of IRAs and employer-sponsored retirement accounts like 401ks, 403bs, 457 plans. Now, there were some big changes made to the options in December of 2019 when Congress passed the Secure Act into law. The Secure Act actually took away one of the most valuable options that were available to non-spouse beneficiaries called the stretch provision. So in this video, I'm going to kind of go over the old rules, what the new rules are for years 2020 plus for people that already have inherited IRAs, what the grandfathering rules were. Can you continue if you elected the stretch option that going forward? There's also some special rules with children that are minors and become beneficiaries of these accounts. And also there's a lot of tax traps with the new law that's signed into place because beneficiaries are really going to have to do some advanced tax planning. Otherwise, they can incur higher taxes. It could impact college financial aid, Medicare premiums, all these other things. So with the passage of the Secure Act, you're going to find that now inheriting these retirement accounts is going to take a lot more tax planning out of the gate. So let's first review how distributions from these inherited retirement accounts is taxed to you. So any money that comes out of these accounts and is paid to you, you have to pay ordinary income tax on. So federal and state income tax, similar to what you get taken out of your paycheck. The one thing you avoid is the 10% early withdrawal penalty if you're under the age of 59 and a half, which is what usually applies if you take money out of IRAs or 401ks early. Because it's considered a death distribution, doesn't matter what your age is, you don't incur that 10% penalty. So before we get into all the changes, we first have to review what the rules were before 2020 before we discuss what changed. So if you inherited a retirement account prior to 2020, you had two options. One was distribute the full account balance within a 5-year period and pay tax on those distributions. Or option two was you could roll over that entire balance to your own inherited IRA, which was a non-taxable event, and then you just had to take small required minimum distributions each year based on your own life expectancy. And by choosing option two, you didn't incur any big tax events because the distributions were relatively small. Now the Secure Act for 2020 going forward eliminated what was called that stretch provision. You are now no longer able to roll that to an higher inherited IRA and stretch those distributions over your lifetime. The stretch provision was replaced with the 10-year rule. So similar to what option one used to be, which is depleting the account in 5 years, now going forward, if you are a non-spouse beneficiary of an IRA retirement account, you have to deplete that entire retirement account balance within a 10-year period. So since the 10-year rule is really the only option available to non-spouse beneficiaries years 2020 and going forward, let's discuss the details of that as well as the planning tax implications you may want to consider. Now, the IRS has pretty much come out and said, we don't care how and when you take those distributions from that account. The only rule is it has to be completely distributed by the end of year 10. So I could take it all in year 1, I could take nothing and take it all in year 10, or I could split the distributions evenly over a 10-year period. Now, this is where the strategy comes into play because remember, all those distributions that come out of the retirement account are taxable income to you. So if I inherit a $200,000 retirement account and I distribute it all in a single tax year, I'm going to have my earned income from working. They're going to put that $200,000 I distributed up on top of that, and they're going to probably pay a super high tax rate on the $200,000. So it's almost money I'm just handing to the government that I could have avoided if I just spread that $200,000 evenly over a 10-year period. Now, the default of just spreading it evenly might not be the best tax strategy either, and I will give you a few examples here. So if I have kids that are going to college in a few years, financial aid looks at my income and it looks back 2 years. So if I'm distributing money from these retirement accounts and I'm showing higher income, I might be losing financial aid 2 years down the road, where if I didn't take those distributions and waited till the kids are later in college, then I can get my financial aid and retain more of my inheritance. Also people that are approaching retirement. So if I'm getting a paycheck for the next 2 or 3 years, I probably don't want to take a lot from these retirement accounts because, again, it's going to get stacked up on top of my income and I'm going to pay it at a higher rate. Probably makes sense to just delay those distributions from the retirement account until after I'm done working. Then as I take that taxable income, it's probably going to be taxed at a lower rate. Now, for people that are already retired, you have to be very, very careful about how and when you take these disbursements. The reason being is if your taxable income goes up, it can impact the tax rate that you pay for Social Security. It can impact the premium amount that you pay for Medicare Part B and Part D. You might be getting property tax credits such as the enhanced star, which you could lose. For normal taxpayers, if you're showing more income, you could be losing tax credits, deductions that might prevent you from contributing to Roth IRAs. So these are all considerations that as soon as you come into that inheritance, you must have to start mapping out that 10-year period to determine what's the most advantageous way for me to deplete this retirement account over the next 10 years. The one item that I do want to clarify is there is no RMD, a required minimum distribution requirement, under the 10-year rules. They don't make you take a small piece each year. That was under the old inherited IRA stretch provision. Non-spouse beneficiaries had to take those small amounts each year. That does not apply to the 10-year rule. You can decide not to take any amount in a single year, or you can take it all. It's completely up to you. Now let's talk about who's grandfathered in under the old rules. So if you already had an inherited IRA and you were taking your RMDs from it prior to 2020, you can continue to do that over your lifetime. They are not going to force you to now distribute that balance over the next 10 years. So you're grandfathered in. So really the line that's sanded, if the person that owned the retirement account passed away prior to January 1st, 2020, you still have that stretch provision available to you, which allows you to roll that over into an inherited IRA and take small RMDs over your lifetime. It's only if they passed away January 1st, 2020 or beyond that you are now locked into that 10-year rule that you have to distribute the full account during that period. So like most new laws, there's always exceptions to the rule, and the Secure Act is no different. There's going to be certain non-spouse beneficiaries that will still be allowed to use the stretch provision and roll over their balance to inherited IRAs and take RMDs over their lifetime. And the short list is any beneficiary that's disabled or chronically ill. There are certain exceptions for minor children, but they're limited, and we'll talk about that later. And then probably the most common will be if the decedent was not more than 10 years older than you, then you can still use the stretch provision. So if it was a sibling or a cousin or something of that nature, the stretch provision will still be available even for people that pass away past 2020. So the Secure Act did have special exceptions for children that were minors that were beneficiaries of these IRAs and retirement accounts. So if a child is under the age of majority, which is different based on the state that they live in. So for New York, the age is 18. So if someone's under the age of 18, they're considered a minor. If a minor inherits a retirement account, they're allowed to roll it over to an inherited IRA. They only have to take small required minimum distributions until they reach the age of majority, and then they're required to deplete it in a 10-year period. So someone, let's say we had a 10-year-old in New York, they inherit a retirement account, they got to take small taxable distributions from that account until they reach age 18. Once they're 18, they've got 10 years to just fully distribute that account balance by their 28th birthday. In order for the exception to apply, the child has to be both a minor and a child of the decedent. If they don't satisfy both criteria, they don't get the special exception, and the account balance has to be distributed within a 10-year period. So an example would be if your child inherits an IRA from their grandparents, even though they might be 10, they are on the 10-year clock immediately. They don't get that special RMD until age of majority and then the 10-year period. Because they weren't a child of the decedent, the 10-year period begins immediately. As I mentioned, the effective date for most of these changes is January 1st, 2020. However, if you inherit certain types of retirement plans, they might have a different effective date for this change. So if you end up inheriting a 403B, a 457 plan or a thrift savings plan from someone that was covered by a state, local government, or federal agency, your effective date of this change is actually January 1st, 2022, which means if someone passes away prior to January 1st, 2022, and you inherit one of these accounts, you will still have access to the stretch provision, which will allow you to roll over that balance into an inherited IRA and stretch those small distributions over your lifetime as opposed to the new 10-year rule. The same is true for employees that are covered by collective bargaining agreements. They also have that January 1st, 2022 effective date for the new rules to take effect. In summary, the passing of the Secure Act is just going to cause non-spouse beneficiaries to do a lot more advanced planning right out of the gates. Before it was easier because we really just had to get that account over to an inherited IRA and set up those RMDs a year after, but it never really created this huge tax impact because those RMDs were relatively small. Now with the potential of these distributions being larger, really as soon as you inherit one of these accounts, you really have to be speaking with someone that knows the tax and financial strategies that might allow you to shelter some of this for income. We have a number of strategies we use with clients, such as if money's coming out of IRAs, you might be able to contribute more to an employer-sponsored retirement plan via deferrals if you're covered, which kind of says, hey, it's taxable on one side and I get it tax-free on the other side, so it kind of wipes out the tax impact. But there's a number of other strategies that we will most likely be using with clients to help minimize some of the tax impact of the new 10-year rule. If you have any questions or if you would like us to share some of those strategies with you, feel free to contact us at moneysmartboard.com. Thank you.